Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and
defendant to
enjoy
make
the
sure they
show.
can hear.
Yep.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Okay, sir. You're here on one count of aggravated battery. Court is reviewing the arrest affidavit at the moment. I'm going to appoint the Office of the Public Defender to represent you in the meantime. All right, the court's reviewed the affidavit and has determined there is probable cause for the aggravated battery. State, do you have a position as to appropriate bond in this case?
The state would leave this up to Your Honor.
All right. He does not qualify for PTO, right? All right, sir, I'm going to set bond at $500. Order that you have. There's some people here. Is anyone here for the victim here for this case? I guess not, right? Okay. Because the alleged victim is not present, sir, I have to order that you have no contact with the alleged victim. Is this his residence, counsel? Oh, it is, right?
I believe so, Your Honor.
I also have to order that you don't return to the residence. I will allow you to return to the residence one time with the accompaniment of law enforcement to get any personal belongings. Then you have to go stay somewhere else until further order of the court. Do you understand that?
Sí.
Yes.
All right. It's under those conditions. Bond says $500. Have a nice day.
Gracias.
Thank you. Your Honor, and if the interpreter could respectfully request a name and case number for this defendant, please.
Yes, it's Ricardo Molina, 2022 CF 10265AO.
Thank you, Your Honor.
All right, the next one, Luis Rivera Torres, 2022 CF 10271AO.
Thank you, Your Honor. Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
All right. Sir, what's your name?
Luis Gabriel Rivera Torres.
Luis Gabriel Rivera Torres.
Sir, you're here on 2 counts, aggravated assault with a firearm, and 1 count of aggravated assault with a firearm, domestic violence. I'm going to appoint the Office of the Public Defender to represent you. These came in on no bond. Court is going to set a bond. Oh, I'm sorry. I didn't see you there. I'm sorry. Ma'am, what is your name?
Natasha Alicea.
Speak up into the microphone.
Natasha Alicea.
All right, and what is your relationship to this defendant?
He's my ex-boyfriend, the father of my child.
And you are one of the alleged victims in the affidavit?
That's correct.
Part of the conditions of his release, or I can order him to have no contact with you. I can order him to have no hostile contact with you, understanding that these orders are just court orders. Are you currently afraid of him?
Yes.
That was yes?
Yes.
All right, well, I'm going to order as a condition of his bond that he have no contact with you. Okay?
Yes.
Or the other victim in this case. Is that your mother?
She's my aunt.
Do you currently reside with your aunt?
What does that mean?
Do you live with her?
No.
And he doesn't live with you either, right?
He was until the day that everything happened.
Okay. Okay. All right, sir. On count one, we're going to set bond at $5,000. On count two, I'm going to set bond at $500. Condition of your bond is that you do not return to the residence where this occurred. Was a residence, correct? It was a
sorry?
house, is where you got.
Yeah.
So you don't go back to the residence where this occurred. You don't have no contact with either of the alleged victims. No contact means no contact. No text messages, no emails, no contact through third parties. You're also to possess no weapons. That's firearms, ammunition, flamethrowers, grenades, no weapons whatsoever. If you currently have weapons, you need to surrender those to law enforcement within 24 hours of your release. Anything further, state or defense?
Your Honor, if he has any belongings at her residence, can he have a one-time return with law enforcement?
Does he have anything at that house?
Everything that he had, I took it out and I placed it outside. He picked them up already.
Okay.
Okay.
That works.
Is that true? I mean, if you want to go back, if there's stuff in there, but if you have everything, I don't want you to go back.
No, everything in the house.
En verdad que no.
Not really.
Okay. Well, based on the representations, I'm not going to allow you to go back even once. That can be modified by further order of the court. But as of right now, based on the representations that were made here today, you're to not return to that residence. You understand?
Sí.
Yes.
All right, thank you, sir.
Sí.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Okay. Ma'am, what is your name?
Marianela Cobas.
Marianela Cobas. Cobas, yes.
Yes.
How do you spell your last name?
Cobas.
Cobas.
All right, let everyone know that the arrest affidavit spells it Cabos, Cabos. To the extent that needs to be fixed, just so everyone's aware. Ma'am, you're here on one count of battery domestic violence. The court's reviewed the arrest affidavit, does find there is probable cause. Your daughter is not here, so I have to order that you have no contact with her until further order of the court. Also have to order that you do not return to the residence. I will allow you to return one time with the accompaniment of law enforcement to get any personal belongings. And then you got to find somewhere else to stay until further order of the court. Also order that you have no weapons. And that you have no, I think I already said, but no contact with the alleged victim in this case. Based on the allegations in the arrest affidavit, I'm also going to order that you consume no alcohol. I'm going to set bond at $500. Also appoint the Office of the Public Defender to represent you. If you bond out, please stay in contact with your attorney. Have a good day.
Your Honor, the interpreter could respectfully request the case number for this last defendant, please.
Can you give it to him? I'm sorry, I don't have it.
22 MM 514 AW.
Thank you.
Thank you very much, Madam Clerk. Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
All right, sir, what is your name?
Es being Aníbal Castañón Vázquez.
Clarification, Your Honor. Repeat.
Es being Aníbal Castañón Vázquez.
Es being Aníbal Castañón Vázquez.
Sí.
Yes.
All right, sir, you're here on an arrest warrant with one count, of aggravated battery. The bond on the warrant was set at none. Court's going to set bond on that count at $2,000. With the conditions that you do not return to the scene of the alleged battery, you have no contact with the alleged victim, and you do not possess or own any firearms or weapons. I'm also going to appoint the Public Defender's Office to represent you in that case. And that is case number 2022 MM 499 AW. So it was a misdemeanor battery. Domestic violence. Bond is still going to be $2,000 with those conditions. Court's also going to order you to consume no alcohol. You're also out on bond in 2022 MM 499 AW. Just one count of DUI and operating a motor vehicle without a valid driver's license. One second. PD, do you know his next court date on the DUI?
On my paperwork, it says September 8th at 1:30. as well as on the novella deal.
Okay. I'm going to revoke the bond in those cases, set bond at none. You have court coming up. What is that court date? Do you know? I know it's September 8th, but what's it for?
I believe it's a pretrial conference, Your Honor. I could be wrong, but I believe it's pretrial conference.
He already has the PD on those cases, though, right?
He is a private attorney on both of those cases, Your Honor.
Okay. I'm going to set the bond at none on those cases until further order of the court. Thank you, and you have a step outside. Mhm. It was one court, it was one case.
Escucho.
22 CT 892 AW, 22 CT 893 AW.
Yeah, 89283. Oh, I might,
I think this case might have been the case that he said.
whoops,
It's okay.
yeah, sorry.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Sir, what is your name?
Ramon by Luis Cruz.
Clarification, Your Honor.
Ramon Luis Baez Cruz.
Ramon Luis Valles Cruz.
Sir, you have two cases. The first is 2022 CF 10264 AO. Count one is trafficking in fentanyl, 28 grams or more. Count two is possession of cocaine with intent to sell or deliver. Count three is possession of cocaine. Count four is possession of fentanyl. And count five is possession of drug paraphernalia. Court's reviewed the arrest affidavit in that case. Finds there to be probable cause. That's to each count. Count one came in on a bond of $2 million. Court's going to reduce that to $1 million. And $150 on counts $150 on each count 2 through 5. Also appoint the public defender's office to represent you in that case. I'm also going to appoint the public defender's office to represent you in 2022 CT 5001 AO. Is that what that says? 5001?
Yes.
Okay. That's one count of no valid driver's license. Court's going to set bond on that count at $100. Special conditions of bond on each case: that you possess and consume no controlled substances without a prescription. Thank you, sir.
Thank you.
Sí, sí lo escucho.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Okay, sir, what is your name?
Francisco Millacura.
Francisco Millacura.
All right, sir, you're here on one count. Well, you have two cases. The first is 2022 CF 10228 AO. It's one count of possession of cocaine. Court's reviewed the arrest affidavit, finds probable cause, will stay the bond at $1,000. We'll appoint the Public Defender's Office to represent you. Condition of bond is that you possess and consume no controlled substance without a valid prescription. In your second case, do you have the case number on that one?
No, we don't have a citation for it.
Oh, we just have a citation for, so no case number, Mr. Interpreter, yet.
No worries, Your Honor. Thank you.
It's no valid driver's license. Court's reviewed the affidavit, finds probable cause, stay that bond at $250. Thank you, sir.
You said the public defender was appointed on the second case, Your Honor?
I didn't, but I was about to. Public defender's appointed on the second case. Thank you.
Sí.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
Sir, what is your name?
Leiden Mejía de León.
Leiden Mejía de León.
All right, sir, you are here with two traffic cases, 2022 CT 809 AA and 2022 CT 810 AA. Second. So 809, I'm going to appoint the Public Defender's Office to represent you in both cases. Is 809 the driver's license case, counsel, or which one's which?
Let me check, Your Honor.
Oh, I see. 809 is the driver's license case. So in the first case, it's one count of operating a motor vehicle without a valid driver's license. Court finds there's probable cause. Set bond on that case at $100. Second is a one count of DUI. Court finds probable cause. Set bond to that case at $500. Condition that you consume or possess no alcohol or illegal drugs. Okay?
Mhm.
All right, thank you, sir. I don't
Thank you.
Your Honor, the interpreter can confirm this defendant is able to hear through the headsets.
All right, sir, what's your name?
Joshua Perez.
Clarification, Your Honor.
Joshua Perez.
Joshua Perez.
All right, Mr. Perez, you're here, one count disorderly intoxication, one count misdemeanor battery. Court's reviewed the affidavit, finds there's probable causes as to both counts. I'm going to appoint the Public Defender's Office to represent you.
May I be heard as to conditions of release, Your Honor?
Yes.
Just based upon the allegations in the affidavit, we would ask for either ROR or mental health pretrial release if he qualifies.
We screen him for, or? Okay. So can we screen him for pretrial, see if he, mental health pretrial release, if he qualifies, to see if he qualifies? How does that work? Okay. Okay. Yeah, the court agrees, based on review of the affidavit, order the defendant be screened for mental health pretrial release, and if he qualifies, to be released as such. And the alternative, court's going to stay the bonds on each count. Special conditions that you consume no alcohol or illegal drugs, and that you take any prescribed medication as prescribed. Also order that you do not return to the Miller's Ale House where this is alleged to have occurred, and that you have no contact with either any of the alleged victims or witnesses in this case. Also, order that you possess no weapons or ammunition. Do you understand?
Sí.
Yes.
All right, thank you, sir.
You said a bond?
State 'em.
Oh.
If you,
Your Honor, if the interpreter could respectfully request the case number for this defendant,
yeah,
please.
sorry, 2022 MM213AE. That if he qualifies, he can be released non-monetary on mental health PTR, but if he doesn't, those are the bonds. Yeah.
And Your Honor, does the court require any further assistance from the interpreter at this time?
I think that's it. Thank you very much. Enjoy the rest of your day.
You as well, Your Honor. Thank you very much.
Bye-bye.
Mr. Reyna Torres was a refusal.
Reyna Torres, okay. Well, he came in on a warrant. So he's a refusal. Do we just stay that, or I forget? Do we stay it or do we reset it? It's a warrant. Yeah, we'll appoint the public defender to represent, or is this just an out-of-state warrant, or does he have an Orange County case too?
It looks like it's Osceola County, Your Honor.
Oh, it's Osceola County? All right, well, I'll appoint the public defender's office to represent him. And at this time, we're gonna stay the bonds per the warrant.
And we don't need to reset it, Your Honor. We'll waive his appearance.
Okay, no wait, that's right. It's all coming back.
Her appearance.
And who was that? That was Reyna Torres?
That's correct, Your Honor. And then there's someone in need of a Creole interpreter.
Creole? Okay,
So we're waiting.
all right. Is that Emmanuel Paul?
Yes.
All right, so we'll pass him for now.
As to Mr. Hall's case, Your Honor, we'll waive reading of the charges.
Okay. All right, sir, what's your name?
Zion?
Hall?
Hall? Yes, sir.
All right, sir, you're here on an arrest warrant. You came in on no bond status. Party stipulate he is entitled to a bond, correct?
Yes, Your Honor.
state have a position as to, we'll go ahead and appoint the public defender's office to represent you. If you want to, we'll do that, for today, and if you wanted them to continue to represent you, they can, obviously can. If you want to hire your own attorney, you're free to do that as well.
Yes, sir.
Your attorney has waived reading of the charges, so we're here just to set a bond for you today, okay?
Yes.
Does the state have a position on, appropriate bond?
State would ask for a higher bond than,
Okay.
one that would match with the bond, schedule, Your Honor.
Give me 1 second.
That's not what we're talking about today. We just gotta talk about bond amount, okay?
I got through most of these prior to coming in here today, but there are some that I didn't get a chance to read, so thank you for your patience, just allowing me to read them right here, okay?
No problem, Your Honor.
All right, sir. On count one, court's gonna set bond at $15,000. Count two, gonna set bond at $500. Special conditions of the bond, you're not to return to the residence where this is alleged to have occurred. You're to have no contact with the alleged victim or with the alleged victim or the alleged victim's mother. No contact whatsoever. That's through Facebook, Instagram, TikTok, text messages. No contact with the alleged victim or the alleged victim's mother. And no return to the residence where this was alleged to have occurred. You're also to possess no weapons or ammunition as a condition of your bond. If I haven't already, I think I did appoint the Office of the Public Defender to represent you. So if there's nothing further, you can have a step outside, okay?
Just a second.
All right, ma'am, what's your name? Ms. Oliveira, you're here on a warrant for failure to appear where, at an arraignment, the bond was set at none. I'll appoint the Office of the Public Defender to represent you. Court's going to stay the bond at none per further order of the court, unless there's argument from counsel. I know you guys were talking. That's the only reason I said.
Yeah, sorry, Your Honor.
Yeah,
She was
that's
just
okay.
explaining.
That's the page up here, right? What's all that? Yeah.
So P- But you have an attorney now, so you're going to. You just got appointed as a health provider. And unless you have somebody on the outside that can contact us, could do that. Thank you, Your Honor.
All right, sir, what's your name?
Raymond Ferguson.
All right, Mr. Ferguson, you're here on one count of trespass on property after warning. I reviewed the affidavit. I do find there's probable cause. I'm going to appoint the public defender's office to represent you. On that count, I'm going to ROR you with condition you don't return to Lake Eola Park, okay?
Yes, sir.
You were also out on bond with petty theft with prior theft convictions. Court's going to take no action on that bond, okay?
Thank you.
You're welcome. Just try to avoid the police.
Yes, sir.
All right, I'll appoint the office of the public defender to represent you if I haven't already, okay? All right.
Go straight back.
You want these or no?
I think they keep them.
Okay. All right, sir, what's your name?
Thaddeus Anthony.
All right.
Judge,
So this was reset. Yeah, go ahead.
do you happen to have the affidavit for this case? I couldn't see it in the court file.
Yeah, this is one that I hadn't read yet. It looks like it was,
It was a warrant, but
warrant.
I don't have the actual affidavit with the allegations for the warrant.
I don't have the affidavit to which the warrant was issued. I just have the affidavit where the cop came in contact with you, ran you through teletype and found the warrant. That's the only affidavit I have.
Yes, Your Honor. I also I don't have like the probable cause affidavit or anything like that.
Okay. All right, so there's already been a probable cause determination made by the judge who issued the warrant on the robbery by sudden snatching. The bond in that case was set at $2,500. He's also out on bond in 2021 CF 15721AO. He was out on bond on that case since December 11th, that has to be 2021, because December 11th, 2022 has not happened yet. since December 11th of last year. The allegations within the warrant said on or between August 29th, 2022. So the warrant alleges that these new allegations were while you were out on bond on the aggravated assault with a deadly weapon. That being the case, the court's going to revoke bond on that case and set bond at none until further order of the court. Okay? And I'll appoint the public defender's office to represent you on each case. It's just not going to be, it doesn't mean you're never going to get a bond, just means until further order of the court, there's not going to be a bond based on what the information the court has today, that you were out on bond on aggravated assault with a deadly weapon, picked up a new charge while you're out on bond, therefore you're not entitled to a bond any longer. So just for today's purpose, it's initial appearance. The court's going to set the bond, revoke the bond in that other case, set it in none. I've appointed the public defender's office to represent you, so you have attorneys that can put the appropriate motions before the court. But today, today, that's all we're doing.
You did an Anamana for this?
All right, good luck, sir. All right, sir, what's your name?
Oh.
What is it?
This the
Oh,
Manuel Paul.
oh, they're on. Oh. Interpreter, can you hear me?
Yes, I can hear you.
All right, we have one case that requires the services of the Creole interpreter. He is standing at the podium, so you want to, I don't know. We'll just get going, okay?
Let me introduce myself, and
All
then let me go ahead and introduce myself to the other party, and then we'll begin, okay?
Okay.
Bonjour, nous parlons de Jean, et moi c'est un interprète. C'est moi-même qui va l'interpréter pour aujourd'hui, hein, ok?
Oui.
All right, sir, what is
The
your name?
interpreter is ready to begin.
Emmanuel Paul.
Okay, comment on relais?
Emmanuel Paul.
All right, Mr. Paul, you're here on one count of
Manuel
aggravated
Paul.
child abuse. I've reviewed the affidavit. Do determine there is probable cause. I'm going to appoint the office of the public defender to represent you.
Et bonjour, Monsieur Paul. Là, et pour un cas de représentant pour abus sur enfant. Et moi, j'ai gardé Affidavit là. Et moi, pour aller appointer et mon représentant pour le cas représenter.
The court, after reviewing the allegation, feels an appropriate bond in this case is $25,000.
Et tribunal là, il garde allégation, hein, et gagnant est bon et pour payer le cas ça, qui c'est $25,000.
Vous pouvez répéter pour moi, s'il vous plaît? Moi, si on va attendre bien, on dit loin.
Can you please repeat for me? I cannot hear you. So this is the interpreter here. Can you hear me okay?
You could speak up a little bit. I can hear you okay, but the volume's a little low.
Okay, okay, can you please repeat that? This is the interpreter here. Sorry.
The court,
Yeah, this is the interpreter. Can you please the last? Okay.
do you need me to repeat, or you need to repeat the last thing I
Yes.
said? Okay. Having reviewed the affidavit, the court feels that an appropriate bond is $25,000.
Et après que nous finissons garder et affidavit là, tribunal lui décide qu'on va payer un bon de $25,000.
Combien?
How much?
Give me one more second. I'm looking at it again.
Bon, mon seconde, bon, regardez encore.
Yeah, $25,000.
25 000 dollars.
I'll also require that you have no contact with the alleged victim in this case.
Et nous demandons pour que vous pas entrer dans aucun contact avec victime de cas ça.
Until further order of the court.
Jusqu'à ce que le tribunal la baille nouvelle ordre.
I've appointed the Office of the Public Defender to represent you. Also order that you,
Et moi apprêté,
go ahead.
et moi apprêté et service défense publique là pour défendre nous.
Also order that you possess no weapons. And that you do not return
Et
to
on
the,
pas supposé
that you do not return to the residence where this is alleged to have occurred.
et moi bail l'autre que vous pas supposé posséder aucune arme et que vous pas supposé retourner dans résidence côté et ça t'est passé hein.
I will allow you to go back one time with the presence of law enforcement to get any personal belongings.
Et ma bonne autorisation pour aller une seule fois ensemble avec présence et renforcement de la loi, autorité, et pour qu'apprendre tout et bagage personnel ou.
After that, you have to find somewhere else to stay until further order of the court.
Et après ça, vous supposez chercher un autre côté pour arrêter jusqu'à ce que le tribunal la baille nouvelle ordre.
On peut poser question?
Can I ask a question?
You can understand everything you say can and will be used against you, and you have the right to remain silent.
Ou capable, mais moi je veux connaître que tout ça que vous dites, il a prêté et il a qu'à utiliser contre vous et que vous avez droit pour rester silence.
Understanding that, you can ask a question if you want.
Oui, et question qui
Et
me
je
pose.
comprends samedi, hein, ou comprendre, ou poser question là si vous voulez.
Ok. Et première question, c'est comme ça, comment m'a payé les 25 000 $, ça c'est comment. Pour qui ça exactement payé et puis comment m'a payé?
My question is, this $25,000, why exactly I'm paying it and how will I be paying it?
You can work with a bail bondsman. Typically, it's about 10%. So $2,500 with the promise you'll show up to court.
This is the interpreter here. Can you please say that once again?
Yeah. If you go through a bail bondsman, the typical rate's about 10% or $2,500 with a promise that you'll show up to court.
Et ou ka parler ensemble avec un homme qui de bon, là-bas où est un taux de 10%, qui c'est $2,500, avec promesse que vous va tourner dans le tribunal là encore.
If you still can't afford it, you have attorneys who can file the appropriate motions.
Et si vous toujours beaucoup qu'à payer lui, et ou gagnez un avocat qui a rempli et forme pour motion appropriée.
Okay. But today the bond's being set at $25,000.
Mais pour aujourd'hui, hein, et bon, hein, yo mettez lui à $25,000.
Okay.
Ok, ça veut dire que je suis capable d'aller et puis pour me capable joindre un avocat ou bien un monde qui peut aider dans ce sens.
So that means that I can go and find an attorney that can assist me with that. In that case,
I've appointed the public defender to represent you. They are attorneys who deal with this type of thing all the time.
et moi j'ai appointé et défense publique là et pour aider ou yo c'est yo gagne avocat et you can habitué aider et dans ce sens ça déjà.
If you want to hire your own attorney, you're free to do so. But you have an attorney appointed to
Mais si
represent
vous
you at this time.
voulez mais si vous voulez embaucher propre avocat ou libre pour faire ça. Mon gars gagne un groupe avocat gratis qui est appointé pour aider ou.
Okay?
Avec des mkounia là ou bien?
Okay.
Qui veut aider mkounia? Qui veut aider mkounia là ou
I'm going to ask for
bien?
clarification. Oh. They gonna help me now or what?
We're done for today, so it'll be later.
Et nous finissons pour aujourd'hui. Hein. Ça veut dire que c'est après.
Right. So have a step outside. Thank you.
Ça veut dire font sorti de yo. Merci.
All right, sir, what's your name? Mr. Interpreter, we're all set. Thank you very much.
Okay, thank you for using our services and have a wonderful Sunday, sir.
All right, you too.
Bye-bye.
Sir, what's your name?
Yes, sir, William.
All right, Mr. Williams, you came in on a warrant for violation of probation. The bond in that warrant is set at $10,000. The court's going to stay the bond amount of what came in on the warrant, okay?
Yes,
All right, I'll appoint the Office of the Public Defender to represent you. Other than that, you have a step outside, okay?
You don't need it? Okay.
All right, ma'am, what's your name?
Azaria Anderson.
All right, Ms. Anderson, you're here on 3 counts. 1, aggravated battery with a weapon, burglary of a dwelling with assault or battery, and criminal mischief. That's the count 2 state. Is state's position she's entitled to a bond on count 2?
Actually, Your Honor, I did not get the paperwork on this case. I
Count
have-
2 is a PBL, correct?
Oh, yes, Your Honor.
All right. Defense, I'm gonna appoint the Office of the Public Defender to represent you, okay? They're present, they're at the podium. I reviewed the arrest affidavit. I do find there's probable cause as to each count. So the only question left for the court, and we'll get to that, is the amount of appropriate bond. Defense, do you have a position as to appropriate bond in this case?
Your Honor, we'll reserve argument as to count 2 for a later time. I do agree it's a PBL, and if they want to make a challenge as to that later, then they could do so.
All right, so here's what we're gonna do. On your count 2, a burglary with a battery therein is punishable by life felony. You're not entitled to a bond on that case. Where today is initial appearance for a ton of people. Typically, in that case, any arguments you have is that you should be entitled to a bond or reserved for a later date, so we're gonna do that today. So the count 2, we're gonna keep bond at none. We've appointed the Office of the Public Defender to represent you, so they can file the appropriate motions and try to set an appropriate bond in that, okay? As to count 1, we'll set bond at $1,000, and count 3 will set bond at $100, okay? And then we'll just go from there. All right? Thank you.
Any conditions?
Yeah, sorry. Also, because of the nature of this charge, the conditions are going to be that you have no contact with any of the alleged victims in this case. No contact means no contact. That's jail phone calls, that's TikTok, Facebook, Instagram, through third parties. You can't tell other people to relay a message. No contact is no contact. Also, if you are, and this will probably address down the road, but we're going to go ahead and put it in there that you do not return to the scene where this is alleged to have occurred, okay?
Absolutely.
And then also that you possess no weapons or firearms, ammunition. If you have any of those weapons, firearms, ammunition that you, upon your release, you surrender those to law enforcement within 24 hours. If you don't have them, you don't have them, but just we're going to order you not possess any of that, okay?
Yes, Your Honor.
All right, thank you. All right, ma'am, what's your name? All right, Ms. Jackson, you're here on 2 counts. 1 count of battery on a person 65 years of age or older, and 1 count of misdemeanor battery, domestic violence. The court's reviewed the arrest affidavit, does find there's probable cause. Give me 1 second. On count 1, court's going to set bond at $2,500. Count 2, set bond at $250. Special conditions of your bond that you do not return to the residence where this was alleged to occurred. Is that where you live?
Yeah, that's my house.
Okay. Well, because no one's here, none of the victims here, I have to order that you do not return there. I can allow you to go back 1 time under the accompaniment of law enforcement to get any personal belongings, and then you got to go find somewhere else to stay until further order of the court, okay? I'm also got to order that you have no contact with any of the alleged victims in this case, victims or witnesses, okay? No contact means no contact, no Facebook, Instagram through third parties, anything like no text messages, phone calls. You have no contact with any of the alleged victims until further order of the court. These can always be modified, but right now I have to order you have no contact, okay? I'm going to appoint the Office of the Public Defender to represent you. Also order that you possess no weapons, firearms, ammunition. And again, you can return to the residence 1 time under the accompaniment of law enforcement to get whatever you need out of the house. And then you got to find somewhere else to stay until you get another court order that says you can go back and stay there, okay? All right, thank you.
350. And you're all set, you don't need to sign that, that's just for your record.
All right, ma'am, what's your name?
Tara Kovacs.
All right, ma'am, you're here 1 count of aggravated battery on a pregnant person. The court's reviewed the arrest affidavit, does find there's probable cause. Ma'am, what's your name?
Courtney Adams.
Miss Adams, what's your relationship to this defendant?
It's my father's girlfriend.
Okay, are you the alleged victim in this case?
Yes.
All right. Let me ask you this. Are you currently, are you afraid of her?
Yes.
So you don't wish to have any contact with her
No,
whatsoever?
Don't want any contact.
Does she currently reside with you?
She's not on the lease, but yes.
Okay. All right, ma'am. The court's reviewed the arrest affidavit, does find that there's probable cause for aggravated battery on a pregnant person. Going to set bond at $3,500 with the conditions that you have no contact with the alleged victim, and that you do not return to the residence. I can't allow you, and I will allow you to return to the residence 1 time under the accompaniment of law enforcement to get any personal belongings out of the house. And then once you have those, you got to find somewhere else to stay until further order of the court, okay? Until then, that's the only time you can go back. Once you go back and get your stuff with law enforcement, there's got to be law enforcement there for you to go back, get it, whatever you need out of the house, and you can't go back, okay? And you can't go back there unless law enforcement's there.
Yes, sir.
Also order you have no, I think I said, but no contact with the alleged victim. That's That's Facebook, Instagram through third parties. You can't have, you know, her dad, it's your dad, that's the,
Yeah.
okay. You can't have, him relay messages to her or vice versa, okay? So there's no contact with her, whatsoever. Also require you possess no weapons. If you do have weapons, you need to surrender those within 24 hours upon your release. But if you don't have any, if you don't have them, you just can't possess them, okay? But if you do have some, you need to surrender those within 24 hours. If I haven't already, I'll appoint the Office of the Public Defender to represent you, okay? All right, anything further?
No.
All right, thank you.
Thank you.
All right. All right, sir, what's your name? All right, sir, I have reviewed the affidavit. You're here on one count of misdemeanor battery, domestic violence. I've reviewed the affidavit. I do find there's probable cause. Ma'am, what's your name?
Bibi Loknath.
I'm speaking to the microphone. I can't hear you.
Bibi Loknath.
Okay. You're the alleged victim in this case?
Actually,
What's
pardon me? Pardon me?
Are you the alleged victim in this case?
Yeah.
Okay.
But,
All right, are you,
can I say something?
you two currently reside together?
Yeah, that's my brother.
Okay.
And I wouldn't like the matter go further because he had a little drink and was just a little misunderstanding. I tried to scare him by calling 911, but I think everything gonna be okay now.
Okay. Are you currently afraid of him?
No, not really, but he had a little drink and was just a little misunderstanding.
Okay.
But I would like if it would just finish, everything gonna be okay.
Okay. You guys, so is you okay with him coming back home?
Yeah, that's my brother and he reside with my mom and me.
Okay.
So I have no problem.
All right, sir. I've, like I said, I have, State, do you have any questions for the victim? Do you have any questions for the victim at all?
Sorry, no, Your Honor.
Okay. All right, based on that testimony, and based on my review of the affidavit, I'm gonna set bond at $250.
Your Honor,
Okay.
he qualifies for PTR.
Oh, even better. You qualify for pretrial release. It's a non-monetary release, but there's some form of supervision, so there might be, you might have to check in and things like that, okay? So we're gonna release you on pretrial release, conditions being you have no hostile contact with your sister. Hostile contact means arguing, you know, it's not just fighting, it's raising your voice, tempers get heated, you gotta leave the room, you can't, you know, no hostile contact is just no arguing, no hostile contact. You can have contact with her otherwise, you can return to the residence based on what she said today. I'm also gonna order you, though, as part of your release, to not consume any alcohol, okay? It seemed to be based on testimony from your sister. I'm not asking you to say anything, I'm just based on her testimony. It may be a reason why we're here. So as a condition of your release, the court's gonna order that you consume no alcohol, okay? I'm also gonna appoint the Office of the Public Defender to represent you. If there's nothing further, you can have a step outside, okay?
Thank you, sir.
Thank you. All right, sir, what's your name?
Brian Hernando Silva.
All right, sir, you're here on one count of battery, domestic violence. I reviewed the arrest affidavit. I do find there's probable cause. No victim is present, so I'm gonna set bond in this case at $500. Oh, sorry, I'm gonna start looking at these in a minute. You just wait, maybe by tomorrow too. You do qualify for what's called pretrial release, like the young man in front of you. That's a non-monetary release, so you're not gonna have to post a bond, but there's gonna be some degree of supervision, okay? As a condition of your release, because the alleged victim's not here, I have to order that you have no contact with the alleged victim, okay? I also have to order that you do not return to the residence where this was alleged to have occurred. I'm also going to order that you possess no weapons. Is this residence, or are you living there? Okay. I'll allow you to go back to the residence one time under the accompaniment of law enforcement to get any personal belongings, and then then you can't go back, okay? You got to find somewhere else to stay. There's no contact orders can always be modified, but just without there being a victim present to hear from, we got to order that you have no contact and you don't return. Okay, that's a court order. and it's gonna be part of your pretrial release, okay? All right, I think I've already appointed the Office of the Public Defender, but if I haven't, we'll appoint them to represent you. And you can have a step outside, all right? All right, ma'am, what's your name?
Linda Logan.
All right, Miss Logan, you're in a similar situation. Look, I looked this time. I looked first. You're here on one count of battery, domestic violence. I see someone coming into the box. Sir, what's your name?
Kenneth Logan.
Kenneth Logan. You're the alleged victim in this case, correct?
Yeah, allegedly.
All right. So I've reviewed the arrest affidavit. I do find there's probable cause based on the allegations in the arrest affidavit. Sir, you get to reside together?
We're married.
Right. So you live together. Sometimes married people don't live together. Sorry.
Well, no, we kind of in a little separation thing right now.
All right. So you guys staying in separate residences?
Yes, sir.
All right. Are you afraid of her?
No, sir. The officers that was there, they seen a little knot on my head, and as goofy as it sounds, it was self-inflicted because I was trying to hide from her. I forgot how old and big I am, and I tried to dive behind the car. That's how I had got a little knot on my head.
I understand.
He didn't hurt me
And
at all.
for today's purposes, we just take everything that's written in here as true. That's the job of the judge today. Like, I understand that.
Right, but they kept trying to get me to do certain things that I didn't want to do.
Trust me, I get it. But for today's purposes, and every domestic violence situation is not created equal. I understand that as well. So,
Okay.
but the charge is the charge, and the court did find probable cause that the elements of a domestic battery did take place. So the only thing we're here to do, she's going to be released on pretrial release, which is a non-monetary release, but there's going to be some conditions. So the reason you're here, do you have any issue with her coming back to the house where you live, or do you want me to order that you two maintain separate residences?
We good.
Well, it's up to you. Well, what would you like?
She can come back home.
All right. And so you also desire to have contact with her?
Yes,
All right, and you're not scared of her in any way?
not at all.
All right. So we're going to release her on pretrial release with the conditions that you two have no hostile contact, okay? Hostile contact, and just so you're both aware, that's arguing, all right? So when you start arguing, that's considered hostile contact, and if you guys are arguing, screaming back and forth, and the neighbors call the police, even if you don't call the police, the neighbors call the police, say there's people arguing next door, it's gonna be a violation of your conditions of release, and you're gonna come back here and you're not entitled to a bond at that point, okay? Just so you know. So it's very important that if you guys can't get along, stay away from each other. But if you wanna have contact, it has to be no hostile contact. The court's not gonna order you to have no contact. The court's just gonna say you have to have no hostile contact, okay?
Okay.
You can return to the residence, based on his testimony. If you wanna maintain separate residences, you can do that too. But if you wanna go back to the house, you're free to do that. Yes, ma'am.
You don't live with me.
That's okay.
Okay.
Yeah, that's fine.
Okay.
But if you wanna go back to the house where this allegedly happened, you can go. The court's not gonna say,
Okay.
the people that came before you, I told them they can't go back.
Oh, okay.
You can go back if you want. You don't have to.
No, that's
you
my
can't-
part.
right.
I got you.
Yeah, okay.
I got a grandbaby.
Okay. All right, so no hostile contact. I'm also gonna order that you possess no weapons, firearms, ammunition. If you do have any of that stuff, you just gotta surrender it within 24 hours. Yeah, other than that, if there's nothing further, you can have a step outside. You should be released as to this charge today,
Thank
okay?
you. All right, Leroy Pittman with a refusal.
All right. Do you waive his appearance, PD, or?
Yes, Your Honor, if
All
we're
right.
appointed.
He was out on bond. Is Laura Parker, is that a public defender? Or is that a private attorney that he had on the, when he was out on bond?
I believe he had a public defender, Your Honor. That case, in clerks, it says it was closed and it's been in PTD since April 13th of 2021.
Okay, we're gonna take no action on that one. We're gonna set bond in this, the court does find there's probable cause. No victim present, so we're gonna set bond at $500, order that he have no contact. The alleged victim. No return. They possess no weapons, firearms. and that if necessary, he may return one time with the presence of law enforcement to retrieve any personal belongings. All right, Sir, what's your name?
Jermaine Summers.
All right, Mr. Summers. You're here on an allegation of violation of no contact order. That came in on no bond. All right, the court's going to set bond in that case, $2,500. You're out on bond on 2022 CF 8214AO, where there was a no contact order in place. The court's going to revoke that bond and set bond at none in that one until further order of the court, okay? Doesn't mean, you know, I'm appointing the public, Office of the Public Defender to represent you. Any appropriate motions related to the bond on that case, they can take care of that for you, all right? Also, well, you know, that no contact order on the other case, it remains in place, but on this new case, we're also gonna, as a condition of your bond in the $2,500 bond that we put on the new case, a condition of that's also gonna be a no contact order until further order of the court. If you wanna get that modified, there's ways to do that, but until it's modified, you can't have contact with this person, okay, with Ms. Ford, all right? So, that being the case, and also order you possess no weapons. If you do have any weapons, you got to surrender those law enforcement within 24 hours of your release. But as a condition of your bond, you possess no weapons, okay? All right, thank you, sir.
Your Honor, Shayna Bennett is a bond.
She bonded?
Yes.
Where's that? That's not Miss Bennett. Good for her. That's a big one. All right, sir, what's your name?
Milton Boyd.
All right, Mr. Boyd, you're here on one failure to appear for a trial management conference. One charge of possession of cocaine. The failure to appear warrant came in at no bond. The court's going to stay that warrant at none until further order of the court, okay? All right, good luck to you.
Your Honor, Ray Combs was refusal.
All right. Mr. Combs had two cases, one with 2 counts of battery, 1 possession of cocaine. I'll appoint the public defender's office to represent him in this case.
And we'll waive Mr. Combs'
All right. I reviewed this one earlier, but I do find there's probable cause as to both counts of battery, as to the aggravated assault with deadly weapon, and as to the possession of cocaine. Court's going to stay the bonds. Count 3, the aggravated assault, 2,500, 500 apiece on the 2 counts of battery. And then possession of cocaine, we'll set that one at $100. All right, sir, what's your name?
Marcus Lee Conyers.
All right, sir. You came in on a warrant on fleeing or attempting to elude. It was the bond on that warrant, count 1 was $1,500, count 2, $1,000 for a total of $2,500. You're also out on bond on 3 separate cases.
3.
Driving while license suspended with knowledge or revoked in 2022 CT 2910 AO. Delivery of cocaine and possession of cocaine in 2022 CF 5085 BO. and possession of cocaine with intent to sell or deliver, and possession of cocaine in 2022 CF 6086 AO. The allegations in the warrant are alleged to have occurred on September 1st. You're out on bond in each of those cases. Court's going to take no action on the dry well. Court's going to revoke bond on all three. And the reason I'm doing that, I was going to revoke bond on just one, but I want you to get time on all of them. So if you're going to be sitting in here, I want you to be getting time on all three cases that you're sitting. So if you're out on bond on two and I only revoke bond on one, you're not, the clock's not ticking on the other one. So
I don't need no time on them because that delivery of cocaine charge been throw it out.
well, you were out on bond, you picked up new charges. What we're doing today, the court's going to revoke bond today on the three that you were out on bond on, set bond at none. I'm appointing the Office of the Public Defender to represent you. Any appropriate motions directed to that, they can take care of, but as what we're here on today, we're just going to revoke bond on those and set it at none. Stay the bonds on the warrant. All right, good luck. That was Conyers, right? All right, sir, what's your name?
Ethel Cooper.
All right, Mr. Cooper, you're here on one count of possession of MDMA ecstasy. I've reviewed the arrest affidavit. I do find there's probable cause. I'll appoint the Office of the Public Defender to represent you. I'm going to stay the bonds at $1,000. Okay? All right, good luck to you.
Tremaine Gaines is a bond.
All right.
We'll waive reading of the charges in Ms. Gillen's case,
Okay.
or Mr. Gillen's case, sorry.
Are any of those PBLs? In count two?
I believe so, Your Honor.
All right.
Certainly count two, Your Honor.
Count one maybe as well.
I just wanted to double check count two. All right, count one.
All right, sir, I'm going to appoint the Office of the Public Defender to represent you, okay? You're here on some new law. The Public Defender's waived reading of those allegations. I've reviewed the warrant. You came in on the warrant with no bond. At least one of these offenses, is count one as well?
Yes, Your Honor.
All right, counts 1 and 2 are punishable by life felonies. In the state of Florida, you're not entitled to a bond without, you're not entitled to a bond on a punishable by life felony. There's some other hearings that may go on down the road. We're not going to have those hearings today. The court's going to stay the bonds on count 1 and 2 at none. And you were also out on bond. Do we know if the new allegations took place?
That's what I don't know.
Hold on. The court's not convinced that the new allegations took place while he was out on bond. They may have taken place prior. So, court, without any other evidence, court's inclined to take no action on the burglary of a dwelling. The case that you were out on bond, I'm not going to touch. I'm going to take no action on that one. But you are going to be held no bond on counts 1 and 2 of the charges that you got arrested on the arrest warrant, okay? Count 3. Let me look. Or counts 1 and 3 are the counts that are PBL. Let me check count 2. False and court's going to set bond on the false imprisonment count at $5,000. And I've appointed the Office of the Public Defender to represent you, so stay in contact with them, okay?
Can I say one thing, please, sir?
If you
I don't know what's going on, other than me getting out on August the 14th, sir.
Listen. So today's just your initial appearance. There was an arrest warrant, so there was an affidavit that was reviewed by a judge, wasn't me, but a judge in this circuit They reviewed an affidavit, determined that there was probable cause to issue a warrant for your arrest on the charges which your attorney waived reading of, because they're kind of serious charges, all right?
Okay.
Right, so the probable cause determination's already been made via that warrant. The judge doesn't sign that warrant unless they found probable cause. So, because the nature of those charges, you're not entitled to a bond unless there's a further hearing that determines you're entitled to a bond. I'm not gonna get into the details of that because it's kind of complicated. So the only thing that happened today is that we just stayed the bonds on those, punishable by life felonies at none. We've appointed an attorney to represent you, so your case is gonna just move forward, with the assistance of an attorney. And, until further order of the court, you're gonna be held no bond on counts 1 and 2. We did set a bond on count 3, or the false imprisonment count. And I took no action on the other case that you were out on bond on, okay?
Okay.
And there are conditions that came in on the warrant. So if you do not to return to the scene of the alleged incident.
I don't know what scene you're talking about. That's what I'm saying. I don't know what's going on, sir.
Right.
I've been released from, I got bonded out. When I got bonded out, I got found with counsel.
Listen.
Surgery. I don't know what's going on.
Listen, I understand. And today's just initial appearance, and so everything you say is being recorded.
No problem.
I understand.
No problem.
May and can and will be used against you. There's nothing really to be gained about talking about the facts of your case here today. It can only hurt you, trust me. Hold on. I'm just letting you know. The warrant's already been signed. So
I understand. I'm kind of frustrated. That's all. I apologize.
I get it. That warrant, though, it came in with some certain conditions, which I'm going to tell you too, okay? So in addition to the bonds we just set, the conditions are that you do not return to the scene of the alleged incident, even if you don't know what's going on, wherever this was alleged to have occurred, can't go back there as a condition of your release. No contact with the alleged victim. Even if you don't know the alleged victim, the alleged victim, you're to have no contact with her, okay? Or him, or whoever it may be. And do not possess any firearms or weapons. Those are conditions of your release. That's just gonna be in your paperwork, okay? All right, good luck to you. Yeah, good luck. That was Guillen's? Who was that? Yeah, okay.
McKenna Henderson was a refusal.
All right. I'll appoint the Office of the Public Defender to represent her. This was a warrant. Any objection? Are we waiving her appearance?
Yes, Your Honor.
All right, we'll stay the bond at 1,000. See. All right.
Don Camp is bonded.
All right. We had her daughter this morning. That was looking, yeah, so.
I put a note, Your Honor.
Yeah.
Bruce Lewis is outside medical.
Bruce Lewis. Okay.
Is it outside medical? So I won't be back tomorrow. Okay.
I'll appoint the Office of the Public Defender to represent Mr. Lewis.
And we'll waive his appearance, Your Honor.
All right.
I just wanted to take a look at the out-on bond case, Your Honor. This is 2002.
I think that was wrong. It's 2022 9777 AO. He was bonded on 8/26. So on that case, court does find probable cause in the possession of methamphetamine. Set bond in that case of $1,000. He just bonded out on 8/26, so we're gonna revoke bond and set bond at none in the case he was out on bond on. And PD is appointed in both cases if they weren't already on the first one. All right, ma'am, what's your name?
Dahlia McMullen.
Do we have Minaj? Minaj? I don't think we did. Yeah, okay.
You didn't need him?
All right, Ms. McMullen, you're here on one case. There's 2 counts. 1 count of possession of MDMA ecstasy, 1 count of possession of less than 20 grams of cannabis. Court's reviewed the affidavit, does find probable cause. We're gonna appoint the public defender's office to represent you. I'm gonna stay the bonds on count one. I'm gonna stay bond on count one at $1,000, on count two, $100. Okay?
God bless you. Antoine Neal is medical.
All right. I'll appoint the office of the public defender to represent Mr. Neal.
We'll waive his appearance, Your Honor.
All right, he came in on account of criminal mischief and possession of drug paraphernalia. I've reviewed the arrest affidavit, do find there's probable cause as to both counts. Set bond in count one at $1,000, count two at $250. When was he ROR'd on the one he was out on? Do we know?
Your Honor, regarding the charges, the state wouldn't have an objection to take no action.
On the one he was out on bond?
Yes, Your Honor.
You have no objection to taking no action?
Correct.
Okay, just making sure. All right, well, that being the state's position, the court take no action onto the case he was out on bond on. All right, sir, what's your name?
Shadi Parrish.
All right, Mr. Parrish, you're here on one case, 3 counts. First count is possession of cannabis with intent to sell. Possession of cannabis greater than 20 grams with a weapon, and possession of a controlled substance with intent to sell. One second. I've reviewed the arrest affidavit. I found probable causes to counts 1 and 2. Okay. Give me 1 second. Was there any PC as to what the pills were?
Your Honor, page 3 of 5 of the arrest affidavit, full paragraph number 3. Full paragraph number 2, sorry. No, I was right. Full paragraph number 3.
Hold on.
Sorry.
Full paragraph number 3?
And 2.
All right, see, is they just say pink pills, they say what they were. I'm not asking you, I have to take every word of this as true just for today's purposes only. Not saying it is true, but I just see where they see pink circular pills. I don't see if he called them anything. That could be Benadryl.
And then the very last paragraph of the affidavit says that they were verified via drugs.com.
Maybe I hadn't gotten there yet. All right, I do see that.
Judge, if I may,
Yes.
I don't believe any of those pills were tested. Just because they were verified on drugs.com doesn't mean that that's what they actually are. There's no field test that was conducted on those.
And was there any question of him whether he had an Adderall prescription?
I don't believe that's contained in the affidavit. I don't know that they asked him that.
All right. All right. with regards to count 1 and 2, I am going to find probable cause. You do qualify for what's called pretrial release, which is a non-monetary release, but it's supervision, kind of akin to probation. It's just there's going to be some checking in and some conditions, okay? But you won't have to post a bond on that to get out. All right?
Postpone.
You won't have to post it. It's non-monetary, but there's going to be some conditions, and if you violate the conditions of release, then you come back. You're not necessarily entitled to a bond. Okay? So, I'm going to find no probable cause as to count 3, so we're going to ROR them as to count 3. Counts 1 and 2, you'll be placed on pretrial release. Special condition that you possess and consume no controlled substances without a valid prescription. Okay? And that you comply with all other conditions of pretrial release. Okay? All right, I'll appoint the Office of the Public Defender to represent you. That being said, you should be released as it relates to this charge today, okay? All right.
Your Honor, can state also ask for no weapons?
Thank you. Because count 2 alleged that there was possession with a weapon, as a condition of pretrial release, there's also going to be a condition that you possess no weapons, no firearms, no ammunitions, no knives, no flamethrowers, grenade, no weapons whatsoever. If you have any of those, you need to surrender those to law enforcement within 24 hours of your release, okay? Doesn't mean you'll never get them back, but you just can't have them while you're out on pretrial release. No weapons, okay?
Yes.
All right, good luck to you.
Thank you, Your Honor.
Mhm. All right. Stacy Ramos, did she?
She's
don't
not
have her?
on my list. I don't know.
Uh, 2202071. Sir, what's your name?
Jonathan Rutherford.
All right, Mr. Relaford, you have 2 cases. First case is 5 counts. 1, possession of a concealed weapon by convicted felon. 2, possession of weapon firearm by convicted felon. 3, possession of weapon firearm by convicted felon. 4, possession of ammunition by convicted felon. And 5, trafficking in cocaine, less than 200 grams with a firearm. That was pursuant to an arrest warrant, which was that set bonds on these. Count 1 through 4, $5,000. Count 5 bond was set at $200,000 for a total of $220,000. Court's going to stay the bonds in that case. Second case is a violation of probation, an out-of-county warrant. That warrant was no bond. Court's going to take no action and stay that bond at none as well, okay? I'll appoint the Office of the Public Defender to represent you on 2022 CF 10210 AO. That's the new law that you came in on, okay? Other than that, yeah, you can step outside, okay?
When is Seminole County gonna? How long?
That's up to Seminole County, but there's a whole, I'm sure they know about it. All right. Yep, good luck. No. All right, sir, what's your name?
My name is Gerald
Gerald, what's your last name?
Slaceman.
All right, sir. You're here. It's 1 case or 2? You have 2 cases. One of them was battery on a person 65 years of older. That was an arrest warrant. Probable cause determination's already been found pursuant to the warrant. Bond on that case was set at $2,000. We're going to stay the bond in that case at $2,000. There was also a separate case with 3 counts: possession of drug equipment, possession of cocaine, possession of controlled substance without a prescription. I reviewed the arrest affidavit, find probable cause in that case. Inclined to stay the bonds on that case. Count 3 of $1,000, count 2 $150, count 1 $100. I'll appoint the Office of the Public Defender to represent you.
Sir, may I ask you something?
Just with the understanding, everything you say can and will be used against you. The only thing we're doing here today is setting terms of release. So what would you like to say?
Sir, can you look at priors, consideration, and not prior offenses here in this courthouse? And take into consideration that I have 3 false arrests that I paid a bond for, and the cases get dismissed. I'm pretty sure that all these cases will be dismissed as well, sir.
All right.
I was asking, can I get a bond reduction of ROR?
The bond is being set in accordance with the fees, the bond schedule. It's not a super high bond. It's an appropriate bond given the allegations in the arrest affidavit. So the court's not inclined to lower the bond or RR you on these charges, but the bonds remain what they are, and they're pretty reasonable. So. What's that? Okay, sorry. And as a condition of your bond on the battery case, there was conditions that were in the warrant that you have no contact with the alleged victim and you do not possess any weapons or firearms.
May I ask who the victim is?
According to the affidavit, it's Jerome Ford, who's 76 years old. So that's the probable cause for that the judge issued. He said a $2,000 bond, but there's also conditions that you have no contact with Jerome Ford.
Jerome Ford also has a bond set out for me from Seminole County. How does that
All right, sir, we're set the bonds. I understand you got a lot you want to say, but that's not the place to do it here today. All we're doing is terms of release, okay?
Do I have to get an ROR bond?
Nope.
Even with my prior
Nope.
appearances?
Nope. Good try.
Have a good day.
Yeah, you too. Yeah. It was 1,000, less. 1,000. Yeah, 100, 150, 1,000. Uh-huh. All right, Stone.
Stone was a refusal.
All right. I'll appoint the public defender to represent Mr. Stone.
We'll waive his appearance, Your Honor.
All right,
He
I've
also
reviewed-
qualifies for pretrial release.
Yeah, I reviewed the arrest affidavit. I do find probable cause. So he qualifies for pretrial release. We'll release him on pretrial release. Require him not to possess or consume any controlled substances without a prescription.
Carlos Torres Cardona was a refusal.
All right, well, appoint the Office of the Public Defender to represent Mr. Torres Cardona.
We'll waive his appearance, Your Honor.
All right, this was a warrant. We'll stay the bonds, 1,000 on count 1, 250 on count 2.
Rafael de la Verde is outside medical.
All right, I'll appoint the Office of the Public Defender to represent him.
He's not going to be back. And we'll waive his appearance, Your Honor.
All right, this came in on no warrant. I believe he is entitled to a bond. State, do you have a position as to an appropriate bond?
If I could just have one moment, Your Honor.
Sure. I don't have the affidavit that was used to issue the warrant, so the facts at this point are unknown to the court. Or he might not be entitled. Second-degree murder, is that a,
Second degree, Your Honor.
it's F1?
Oh, which? I believe the second count, Your Honor, is a PBL. I think the first count is to be set at first appearance. under the statute numbers they came in as. I'm sorry, both of them are PBLs.
Okay, all right, well, we'll stay the bonds at none then. Appoint the Office of the Public Defender.
Thank you, Your Honor.
Nope, thank
for your
you.
patience.
No, that's all right. All right, sir, what's your name?
Timothy Lyman.
All right, Mr. Lyman, you're here on a warrant for failure to appear. The bond on the warrant's $500. The court's just gonna stay the bond at $500, okay? I'll appoint the Office of the Public Defender to represent you. All right. Thank you. All right, sir, what's your name?
Smith.
All right, Smith, you're here on a warrant for failure to appear on the count of charge of battery. The warrant that was issued had a bond of $500. We're gonna stay the bond of $500. Also, order you have no contact with the alleged victim in this case, okay? I'll also appoint the Office of the Public Defender to represent you. Other than that, you can have a step outside, all right?
Sure. Thank you.
All right, ma'am, what's your name?
Kendra John.
All right, Miss John. All right, you're here just, what's that count to? 322.341. All right, ma'am, it looks like you're just here on a warrant for failure to appear. The bond on that warrant's listed at $500. We're gonna stay the bond at $500, okay? So you have a, and I'll appoint the Office of the Public Defender to represent you, all right? All right, sir, what's your name?
Travis Zipper.
Jose Yepes, does he don't have him? 220-20745. All right, sir, what's your name?
Travis Zipper.
All right, Mr. Zipperer. So Zipperer. All right.
Sir.
You're here on a warrant, 2 warrants for failure to appear. The bond in each of the warrants is set at $200. We're gonna stay the bonds in each of those at $200 each count, okay?
Yes, sir.
All right, I'll appoint the Office of the Public Defender to represent you. Other than that, you have to step outside. And what's your name?
Rosanna Carncross.
All right, ma'am, you're here on one count of violation of a county ordinance. I'll appoint the Office of the Public Defender. Well, let's do this. Say, do you have an offer in this case?
I'm sorry, is this Miss McCray?
This is Alexia.
I don't have this person.
I'm Rosanna.
Oh, Roseanne, oh, sorry. What happened to Alexia Ayala? 220, you don't have her? 220-20740. All right. Rosanna, how do you say your last name? All right, we were here on one count of trespass on property after warning.
Oh, okay. I'm sorry, Your Honor, I found
That's okay.
the right stack of papers.
You live in Fernandina?
Not anymore, but I used to.
That's where I grew up. Don't see people from there every day. Do you have an offer in this case, State?
Adjudication and time served.
All right, ma'am, this is a trespass on property after warning. I've reviewed the affidavit. I do see there is a factual basis or a probable cause to support the charge. The state's offer to resolve your case here today is an adjudication of guilt and court costs. So, and credit time served. So you'd be released if you were accept the state's offer, plead guilty, waive your rights to go to trial on this charge, you'd be released as this charge today. So she does not qualify for PTR. Do we know, has she been screened? The other option the court's willing to do is if you're willing to be screened for mental health pretrial release, we can have you screened for mental health pretrial release, and you can be released as this charge if you qualify on non-monetary. That may take some time to do, but if you qualify, you could be released pretrial release with a mental health designation, and it's just a form of supervision based on the allegations in the complaint. You know, you may benefit from that. It may be something you want to do. It may be something that you just want to resolve the case here today and get it over with, but that's up to you. I can also I will appoint the Office of the Public Defender to represent you. They're standing right there. They're attorneys. If you have any questions, you can run them by that, or run them by her. So what would you like to do?
I would like to resolve the case.
You want to just resolve it? Okay. Your attorney's going to hand you what's called a plea form. Top of the plea form is some rights that are associated with a criminal offense, including the right to go to trial, call witnesses, confront the state's witnesses, have an attorney represent you, all those things. By resolving your case here today, that plea form says you understand you're waiving all those rights, okay? The bottom part of that plea form are some consequences of entering plea, like if you've ever been convicted of a sexually motivated or sexually violent offense, may subject you to involuntary civil commitment under what's called the Jimmy Rice Act. If you're on probation for a separate offense, a plea to this offense might subject you or might be used to violate that probation. And if you're not a U.S. citizen, a plea to this offense would subject you to deportation. The plea form just goes over some of those consequences. Those are the highlights, but by signing the bottom of that plea form, it says you understand, you've read the plea form and you understand it, okay?
Yeah, I just want to solve it.
We have Raul Cruz. So, 220-20753. Thank you. All right, thank you. All right, ma'am, I'm handed a plea form. You had the opportunity to read and go over this plea form. You understand that by resolving your case here today, you're waiving the rights that were listed on this plea form?
I'm sorry.
No, it's okay.
The rights.
I'll repeat it. It's all right. There's a lot going on. You understand that by resolving your case here today, you're waiving all the rights that were listed on this plea form?
Yeah.
Yes. Ma'am, if you want to take a minute. It's okay. I understand. If you're not,
I'm sure that the person I loved all my life is done right, you know, so.
if you're not comfortable resolving your case here today, you don't have to do that. You understand that, right?
Yeah.
Okay. I just don't want you to feel like this is something you have to do. All right? So let me know when you're ready. Take your time. Whenever you're ready, we'll pick up, okay? And if at any moment you have any questions, it's fine. We'll stop and answer your questions, okay? All right, so where we left off is that you understand that by resolving your case here today, you're waiving the rights that were listed on this plea form?
Yes, sir.
All right, including the right to go to trial and the right to have an attorney represent you? Okay. I know, this, probably not, probably a pretty bad day for you. Probably a bad couple days. So as I go through this, there's no trick I just want you to know, there's no trick questions. This is just part of, if you want to resolve your case, we just got to make sure you understand your rights and that you're freely, knowingly, and voluntarily waiving those rights. It happens every day in these courtrooms. So I know it may be unique to you. So if it feels like we're kind of running through it and it's just know that we do it every day. It may be new to you. So if at any moment you want me to stop and repeat something, you're not hurting my feelings, okay? We went over some of the consequences of entering a plea, including if you're not a U.S. citizen, a plea to this offense would subject you to deportation. Do you understand that?
Yes, sir.
All right, and you understand that if you've ever been convicted of a sexually motivated or sexually violent offense, that a plea to this offense could subject you to involuntary civil commitment? Do you understand that? If it doesn't apply to you, it doesn't apply to you. I'm just asking if you understand. Okay. Are you on probation for any other offense? All right. Do you understand that if you were on probation for a separate offense, a plea to this offense might be used to violate that probation?
Right, I don't think I'm on probation.
Okay, just as long as you understand that entering a plea, if you are on probation, may be some consequences. Okay, you understand that? All right. You still want to resolve your case here today? All right. Well, accept your no contest plea. I'll adjudicate you guilty of the offense, sentence you to credit time served. Was it 2 days, 1 day? One. All right, sent you 1 day in the Orange County Jail with credit for the 1 day you've already served, so you'll be released as it relates to this charge today. There's also some court costs associated with it, right around $300. I'll give you up to a year to pay that. If you want to get on a payment plan, you got to do that through the Orange County Clerk's office. And as long as you're making regular payments and on a payment plan, they're not going to suspend your driver's license, okay? But if after a year you're not on a payment plan and there's still a balance, then they're going to suspend your driver's license, all right?
Yes, sir.
All right, have a step outside and good luck to you, all right?
Sir.
Thank you.
Did you appoint PD?
I did not. I started to and then did it. Yeah.
And Terrence Davis was a bond.
Was he just in here?
Yes.
Good for him. Yeah, he just made it.
Uh-huh.
All right. Man, what's your name?
Wait, you got William Dyson?
Oh,
William Dyson was behavior.
behavior? Okay. All right, we'll appoint the public defender to represent Mr. Dyson.
We'll waive his appearance, Your Honor.
All right, I've reviewed the affidavit, I do find there's probable cause. I'll set bond at $250. I've already appointed the public defender. Okay. All right, ma'am, what's your name?
Lisa Edwards.
All right, Miss Edwards, you're here on one count of petty theft. I reviewed the arrest affidavit, do find there's probable cause. I'll appoint the office of the public defender to represent you. Bond is currently set at $250. I'm inclined to stay the bond unless there's an offer from the state. It's petty theft, I'm not sure if there is one.
Your Honor, I'm not sure the state offering a resolution at this time is the
Okay.
best idea.
Yeah. All right, so we're gonna stay the bond. We're gonna stay the bond at $250. Order you do not return to the AT&T store where this is alleged to have occurred. Other than that, you have a step outside, you do have a bond, okay?
Thank you.
All right, ma'am, what's your name?
My name is Tracy Striplet.
All right, you're here on one count of trespass, failure to leave. We've reviewed the arrest affidavit, do find that there is probable cause. Say, is there an offer in this case? It was a McDonald's, I don't know.
Your Honor, adjudication, time served, court costs, and no return.
All right. The state's offered to resolve this case, if you want to resolve it today, is an adjudication of guilt, so it's a conviction and credit time served, you'd be released as of this charge, and there'd be some court costs. You have the right to an attorney, whether you resolve your case here or not. I can appoint the public defender's office to represent you. Court's inclined to set bond in this case in $250, so you can bond out without resolving your case. If you resolve your case here today, you'll be waiving all the rights associated with going to trial, including the right to call witnesses, confront the state's evidence, have the state prove the charges against you, et cetera, et cetera. But the decision whether you want to resolve your case here today is up to you. So what would you like to do?
Did I hear you correctly? You said that I can't return back to McDonald's.
Not any McDonald's, just that McDonald's. There's one on every corner, so if you really,
Not in Apopka.
oh, okay. Yeah, the condition of is a no return to McDonald's. And that McDonald's, so if that's the only one, we have to go to Burger King. If you want to resolve, you don't have to resolve it today. You can, if you want to bond out, you can bond out, and you'll get a court date.
Well, my financial, you're not considering my financial consideration, like my financial problems? So it's not about whether or not I can bond myself out, it's whether or not I'll be able to bond myself out in time?
Here's what I'm gonna do. I'm gonna appoint the office of the public defender to represent you. They're gonna give you some contact information. You have access to a phone? Not in jail, if you get out.
Yes, I do.
Okay. I'm gonna release you on your own recognizance. That means you're gonna get out without having to post a bond. But as a condition of your release, I'm gonna require you to maintain contact with your attorney. Because if you start missing court dates, warrants are gonna get issued, and you start missing court dates, at that point, you're not entitled to a bond at all, okay? So I'm gonna release you as it relates to this charge. Require you maintain contact with your attorney. That information she's handing you right there. But you'll be released as it relates to this charge today, okay?
Do I have to pay for the attorney?
$50 is at the end of your case, but no. All right, sir, what's your name?
Jackson Joseph.
All right, Mr. Joseph. I didn't. That's all right. There's only one McDonald's in Apopka. I'm not gonna do that to the poor girl. Sorry, state. I forgot to order no return, but there's only one McDonald's in Apopka, so that may be cruel and unusual. I don't know. The Eighth Amendment protection.
Especially with all the addictive ingredients that McDonald's have.
Exactly. Yeah. All right, Mr. Joseph, you're here on one count of possession of cannabis, less than 20 grams. Has a $250 bond. I've reviewed the arrest affidavit. I do find there's probable cause. I'm gonna R you on, unless there's an offer from the state. I'm inclined to release you on your own recognizance, so you'll be released. You won't have to post a bond. I'm going to require you to stay in contact with your attorney. I'll appoint the Office of the Public Defender to represent you on this case. Go ahead.
I have a question. I didn't know that I had to come to the court today, so I paid a bonds bailsman $125 yesterday. Is there any way that I can get that back from them?
That'll be between you and the bail bondsman. I'm going to ROR you today, so you'll be released. You're going to get some paperwork. If I were you, I'd take the paperwork down to the bail bondsman and see what you guys can work out. Yeah. Yeah. Is that on bond on that one? Just give us a second. What was the case number again? 2021? Yep.
It's just a case I've been fighting since last year.
That's all right.
Never.
I'm just looking at it. You already have the public defender on that case.
Yes.
Um,
I'm working on getting an attorney on the case.
That's all right. Oh, public defenders are attorneys. I used to be a public defender. They traffic in county court BS day in, day out. So it may be the best attorney money can buy when it comes to a lot of these cases, just so you know. But you're certainly free to hire your own if you want. Yeah, it's currently set for trial on October 17th. The court's going to take no action on that case. So you're going to be ROR'd as it relates to the cannabis case. And I'm taking no action on the case that you're out on bond on, okay?
Okay.
All right. And I'm pointing the PD in this case as well. So you have attorneys on both your cases. All right? Good luck to you. All right, sir, what's your name?
John Worth.
All right, sir, you're here on one count of trespass on property after warning. You find there's probable cause. State, do you have an offer to resolve this case?
State would offer adjudication, time served,
No return?
no return.
All right, sir.
Yeah. I'd also like to point out, I did give you a piece of paper to bring back to show you were successful in getting an ID. And I was just there 3 hours earlier, 3 hours early to wait for them to open, to give them the piece that they asked. I wasn't. I just want to point out that I wasn't there because I was trying to trespass.
Okay, yeah, as long as you,
Because they told me to bring a piece of paper back.
as long as you're okay.
All right. So you heard the state's offer. Is your indication you want to resolve your case here today?
Yeah, I'd like to do that.
Okay.
Sir.
Yep.
Can I just point out, the only reason I was there a few hours early, because Dignity asked you to bring back a piece of paper once you are successful in getting your new ID.
Mhm.
And I was just there 3 hours early to give them their piece of paper. That's it.
Yeah, I understand. Well, your offer is adjudication of guilt, credit time served. You can resolve your case here today, or you can go to trial and present any defenses. You have the right to an attorney and do all that stuff. If you want to waive your right to an attorney and resolve your case here today, and your right to go to trial, you can do all that. So what would you like to do?
Yeah, that's what I was all.
Okay. That's certainly within your rights, so.
Okay, I don't have plans to be there. I am right here along with it. Yeah. Yeah.
You go ahead and sign at the bottom. That's it. Thank you, Mr. Johnward.
About how long before they get me out of here?
That's up to them.
Thank you. All right, sir.
Thank
We got, no, we're not done yet.
Oh,
He's going to ask you all those questions.
Yeah.
oh, I'm sorry.
I just gotta make sure you understand, we gotta get it on the record. Yeah, I know, I saw you going over this plea form with your attorney. Do you have the chance to go do that with her?
Yeah.
All right. So you understand by resolving your case here today, there's not gonna be a trial and that you're waiving the rights that were listed on this plea form?
Yes, Your Honor.
All right. You understand if you're not a U.S. citizen, a plea to this offense will subject you to deportation?
Yes.
And that if you're on probation for a separate offense, a plea to this offense might be used to violate that probation?
Yeah.
And if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense could subject you to involuntary civil commitment?
Yeah.
You understand that? Yeah, okay.
Yeah.
You under the influence of any drugs, alcohol, medications affecting your ability to understand what's happening here today?
Sure, I wish I would.
You and me both. Anyway. I accept the no.
The biggest thing was, it was my kid's birthday yesterday.
No, it's okay. Well, you're getting out. So adjudication of guilt, court costs, credit time served. I'll give you 1 year to pay the court costs, okay?
All right.
All right, anything else?
Can I ask you one thing? I was arrested for camping last year.
Yeah.
Am I being held under, am I gonna get in trouble for paying court costs on that? Or?
No. That's not what we're here on. So we got a lot of people behind you. So your case here today was taken care of. So good luck to you.
All right, thank you.
Yep.
Have a good one.
You too. All right, ma'am, what's your name?
Laura Price.
All right, Ms. Price, you're here on 1 count of trespass on property after warning. I've read the arrest affidavit. I understand there might be some disagreement as to the facts, but the facts alleged in there do give rise to probable cause. Have you ever been referred to Veterans Court?
No.
No?
And Judge, may I just add, as to the cases she's out on bond in, there's a motion to suggest competency in the 22 MM 2765 AO case.
Okay. All right, so we're gonna take no action on the cases that you were out on bond on. You were out on bond on a battery. All original conditions of your bond in both cases will remain in effect. We're gonna take no action on those cases, all right?
Thank you, Your Honor.
On the trespass on property after warning, given the filing that was made in your other case, we're not gonna resolve your case here today. I'm gonna set bond at $100. All right, anything further? I'm appointing the Office of the Public Defender to represent you on the new case as well, okay? All right.
All set?
Yep, you're all set.
Is that Creole? I'm like, what the heck? All right, sir, what's your name?
Spray.
All right, Mr. Spray, you're here on 1 count of possession of drug paraphernalia. Reviewed the arrest affidavit. Do find that there is probable cause to support that charge. State, do you have an offer in this case?
The state could offer adjudication time served.
Okay. State's offer, if you want to resolve your case here today, is an adjudication and guilt credit time served. Otherwise, the court can set an appropriate bond. You can bond out without resolving your case here today. You have the right to an attorney either way. You have the right to go to trial on these on this charge, and all the rights associated with going to trial, like calling your own witnesses, confronting the state's witnesses, et cetera, et cetera. Again, you have the right to an attorney whether you resolve your case here today or not. What would you like to do?
Resolve today, sir.
All right.
questions? Okay.
All right, Mr. Spray, I was handed a plea form. Did you have a chance to read and go over this plea form?
Yeah, Your Honor.
You understand that by resolving your case here today, there's not going to be a trial and that you're waiving all the rights that were listed on this plea form? Under the influence of any drugs, alcohol, or medication that's affecting your ability to understand what's happening here today? Has anyone threatened you or coerced you to enter this plea? Has anyone threatened you or coerced you to enter this plea? All right. You understand that if you've ever been convicted of a sexually motivated or sexually violent offense, a plea to this offense might be used or could subject you to involuntary civil commitment? You got to answer out loud, yes or no. I just have to answer out loud, yes or no. I see you shake your head, but everything's being recorded, so I just asked if you understood that.
Yes, sir, I do understand.
You understand that if you're not a U.S. citizen, a plea to this offense would subject you to deportation?
Understand.
And do you understand that if you are on probation for a separate offense, a plea to this offense might be used to violate your probation? All right, still want to resolve your case here today. All right, well, accept the no contest plea, adjudicate you guilty, sentence you to 1 day in the Orange County Jail with credit for the 1 day time served.
Yes, Judge.
2 days in the Orange County Jail with credit for 2 days time served. Assess court costs, give you 1 year to pay the court costs. You have 30 days to appeal the judgment and sentence. Have a step outside and you should be released as it relates to this charge today. All right?
Jonathan Vergara was a bond.
All right. All right, ma'am, what's your name?
Kimberly Devin Wozinski.
All right, Ms. Wilzinski. You're here on one trespass, one count of trespass. Do find there is probable cause. There's out on bond on 2 other trespass cases. Do we know if that was the same World of Suds in those other cases?
Discount beverage.
Okay, different spot.
One for the case ending in 343, Your Honor, was a discount beverage.
Right, and then the 003B, same, the discount beverage, both of them, thank you. All right, we're gonna take no action on the cases you were out on bond on. This was I don't know if you have an offer in this case or not, I'll ask.
The state can offer adjudication, time served, no return.
All right, if you want to resolve your most recent case, the World of Suds case, the state's offered to resolve that case as adjudication of guilt, credit time served, plus court costs, and a no return to the World of Suds as a condition of your sentence, okay? Otherwise, I mean, you have the right to an attorney whether or not you resolve your case here today. But if you do resolve your case here today, you'll be waiving your rights associated with going to trial. So what would you like to do?
I would like to sell it today, sir.
Okay. All right, your attorney, or the attorney, I have not appointed the public defender's office to represent you, to save you about $50. But the attorney, as a friend of the court, has a plea form there, talks about your rights associated with going to trial. You ever entered a plea before?
Yes.
Yeah, you familiar with the plea form?
Yes, sir.
All right, so if you have any questions about the plea form, now's the time to ask them. Otherwise, sign at the bottom and we'll go over it. All right, Ms. Wilzinski, do you have a chance to go over that plea form?
Yes.
You understand that by resolving your case here today, you're waiving your right to go to trial on this offense?
Yes, sir, I do.
You understand if you're not a U.S. citizen, a plea to this offense could subject you to deportation?
Yes, sir.
Do you understand if you're on probation for a separate offense, a plea to this offense might be used to violate that probation? Are you under the influence of any drugs, alcohol, or medications affecting your ability to understand what's happening here today?
Yes, sir.
All right. Has anyone threatened you or coerced you to enter this plea?
No, sir.
You understand if you've ever been convicted of a sexually violent or sexually motivated offense, a plea to this offense could subject you to involuntary civil commitment?
Yes, sir.
All right, well, accept the no contest plea, adjudicate you guilty, assess court costs, give you 1 year to pay the court costs. Also sentence you to, should you have 2 days, 1 day? 2 days in the Orange County Jail with credit for the 2 that you already served, okay? So you'll be released as it relates to this charge today. We're taking no action on the other cases.
No return?
And a no return to the world of suds. All right? This world of suds, it could have been either a laundromat or a beverage store. Which, do we know what it was?
World of Suds.
Yeah, it could have been a beer store.
Laundromat.
I don't know, I was just curious. Because I was gonna tell her if she keeps it up, she's not gonna be able to buy beer anywhere. She keeps getting trespassed from all the liquor stores. Anyway, all right, sir, what's your name? Or ma'am, what's your name? I'm sorry.
Tiara Bailey.
All right, Miss Bailey, you came here on an out-of-county warrant that's no bond, so the court's gonna take no action, and it's gonna stay the bond at none, okay? All right, it's an out-of-county warrant, so it's a Seminole County warrant, so the Orange County Public Defender, I can't appoint them to represent you, okay? So you're just gonna sit here until Seminole County comes to get you, all right?
Do you know how long that'll be?
Nope.
Is there like a time frame they have to come get me? Or-
There typically is, but I can't give you legal advice. It's gonna be up to them. It's usually sooner than later.
Okay.
All right, good luck to you. All right, sir, what's your name?
Joel Boyd, sir.
All right, Mr. Boyd, you're here, similar situation on out-of-county warrant that came in no bond. The court's gonna take no action on that bond, okay? So, because it's out of county, I'm not gonna appoint the office of the public defender. You're gonna sit here until that county comes to get you, all right? Good luck to you.
Annabelle Correas.
All right, well, we'll just stay the bond, came in on a warrant, it's out of county warrant. Do we reset her? No, we just, yeah.
Terry Edwards.
What was it? I'm sorry.
She didn't come up, she's out of county warrant. Do we have to reset her, or can we just
No, it's up to you. What was the reason?
refusal?
Yeah,
So
okay.
we're just staying,
Okay.
yeah.
Just so you know, I have no other inmates, so everybody else is just gonna.
Oh, let's,
Okay.
we got 6 minutes. I promised someone 2 o'clock, I could get it done before 2. All right, Terry Edwards.
Mental health.
All right. We'll appoint, no, it's a out-of-county warrant, so we'll stay the bond on him, $10,000. All right, Corey Sanders,
Mental health.
out-of-county warrant. We'll stay the bond.
And Edwards had 2 cases at 10,000.
Corey Edwards has 2,
No, I'm saying Edwards, he had 2 cases at 10,000.
and they're both out-of-county warrants?
Mm-hmm.
Yeah, we'll stay the bonds on both. Yep,
People that just
thank you.
don't want to come to court. Crazy.
What was Sanders? I'm sorry.
Sanders, he was mental health, right? Yep. And he's got an out-of-county warrant, 2 counts, no bond. We'll stay that. All right, Yasir Barodi,
Mental health.
of course, it's gotta be one that's kind of complicated. All right, I'll appoint the office of the public defender to represent, Mr. Barodi.
We'll waive his appearance, Your Honor.
All right. I do find there's probable cause. Count 1 came in and no bond. He is entitled to a bond on that, right? Or is he?
Yes, that's a second-degree felony, Your Honor.
Yeah. All right. Set bond at 10,000 on count 1, stay the bonds on count 2 and 3 at 100. Justin DeJesus.
Mental health.
All right. So VOP warrant, all right. We'll stay the bond, we'll appoint the Office of the Public Defender to represent him on the VOP. Stay the bond at none. There's a trespass on property after warning, do find probable cause, stay the bond at 500. We'll take no, we'll revoke the bond on the case he was out on bond and set that bond at 100. So if he's sitting there, at least he's getting time on it. What's that? Yeah, did you waived his appearance, correct?
Yes, Your Honor.
All right. Rhonda McCray.
Mental health.
All right, I've reviewed the affidavit, noted that there is probable cause. I'll appoint the Office of the Public Defender to represent her. And I'll ROR her as the camping count. Yeah, if defense you waived, correct?
Yes, Your Honor.
All right, that was Rhonda McCray. Jesse Ryson,
Bonded.
bonded. 158, look at there.
Congratulations.
Yeah, to myself.
I appreciate that goal. Can we do that tomorrow too?
Hopefully we're faster tomorrow.
Okay,
Well,
I'll try to figure out my
there
paperwork.
was a lot of, that was a lot, right? Was that relatively a lot for the weekends or no?